Hello everyone, welcome to Easy GST for You, your one-stop channel for simple explanations on complex GST and legal issues. I'm Girish Kulkarni, your host for today's update, which is very important. The Supreme Court has recently delivered a very important judgment that could have a big impact on many ongoing GST litigations across India. In this case, Commissioner of Trade and Tax Delhi versus Shanti Kiran India Pvt Limited, the Supreme Court has held that a bona fide purchase cannot be denied input tax credit merely because the selling dealer failed to deposit the tax with the government or because the seller's registration was cancelled later. So let's quickly understand what has happened in this particular case. The assessee was a genuine trader who had purchased goods from registered dealers and paid the full amount, including VAT, and had proper invoices and other documents. Later, the department disallowed the credit on the ground that the selling dealers had not deposited the tax and their registrations were cancelled. While the tribunal upheld the department's action, the Delhi High Court allowed the assessee's contentions in the appeal. And now the Supreme Court has confirmed this view. The Apex Court made two key observations here. First, that the seller was a registered dealer at the time of the transaction. And second, that there was no dispute about the genuineness of the invoices or the transactions as such. So, therefore, the court held that the purchasers cannot be denied the benefit of input tax credit just because the sellers defaulted in the deposition of tax, especially when there is no mechanism for a buyer to verify seller's compliance. Now, even though this particular judgment relates to the old VAT regime, its its reasoning is very highly relevant for GST as well. Particularly, the disputes where input tax credit is being denied under Section 16(2)(c) of the GST Act, which requires that the tax should actually be paid to the government. The Supreme Court's view reinforces a very important principle that a genuine taxpayer should not be penalized for the default of somebody else, and that input tax credit is a vested right, not a concession. So, what does this mean for taxpayers? So, if your ITC has been disallowed simply because your supplier did not deposit the tax and their registration was later cancelled, this particular judgment gives you a strong legal footing. It can be cited as a persuasive precedent before appellate authorities and courts in similar GST disputes. In short, this ruling is a big relief and a strong step towards fairness in the tax administration. So, bona fide purchasers who have acted in good faith should not suffer for the default beyond their control. That's all for today's update. I'm Girish Kulkarni and you've been watching Easy GST for You. If you found this video helpful, don't forget to like, share and subscribe for more such practical GST and other tax related insights. Thank you so much for watching. Stay tuned.